Okay, everyone, we're talking about Rule 403 in its most common application, which is the substantially more prejudicial than probative test when it comes to admitting or keeping out prejudicial evidence. So we'll pull up the rule one last time for 403 here. The court may exclude relevant evidence if its probative value is substantially outweighed by a danger of one or more of the following: unfair prejudice. That's what we're talking about here. So something very important with Rule 403. When you argue Rule 403, argue it within the language of the rule because it helps you, especially if you're trying to keep stuff out. Probative value substantially outweighed by the danger of prejudice. That means that the prejudice has to be 90% on the 1 to 100 scale, and the probative value has to be like 10% for something to be excluded on prejudicial grounds. So if you're trying to rebut an objection to prejudicial versus probative, if you can prove that this is like pretty damn probative, then no amount of prejudice can really keep it out. It's really only going to apply to things that have very little or no probative value, but have some amount, if not a significant amount, of prejudicial effect. There's a ton of examples. In mock trial, it's easy to get wrapped in trials generally. It's very easy to get wrapped up in stuff that seems prejudicial because it feels to you as a defense attorney or as a plaintiff attorney that like information that hurts your case is prejudicial because obviously it's biasing the jury against you in some way, but that's not quite what it means. It has to be something that inflames the jury's passions, typically playing on their emotional responses or playing on their preconceived notions of unrelated things to like get them to come to specific decisions in a specific case. I'm reading a couple real life examples right here of when prejudicial versus probative has been like delineated. One example is a doctor in talking about his history and practicing and where he got his experience. The defense brought out evidence that he worked in an abortion clinic, trying to lay foundation, as they said, for his expertise. It was kept out on prejudicial versus probative grounds because while there is probative value in learning his expertise, even in this specific instance, the prejudicial effect of learning that he worked in an abortion clinic far outweighs in the jury's eyes the probative value of his of the expertise he gained there. So that's an example where like it's something that should actually help his credibility, that he has more experience, and here I'm going into it, but it's really only being elicited in court to get the jury to dislike him because he's working in a more, in some people's minds, morally reprehensible avenue of work. Other examples are when a character witness makes far-flung analogies and analogizes specific people or instances in the case with other things that are like very bad. Last year, the two thieves, Bowman and Cameron Poole, were likened to Elvis and Costello. Is that their name? Bonnie and Clyde. There we go. The two thieves. So Bonnie and Clyde. And that's prejudicial because there's almost an assumption that they're thieves within that description. It doesn't really add anything. As a Russian witness, I'm apt to say that to liken people to the KGB. I'm likening Jesse Duran to a member of the Soviet Politburo. All of those things don't add anything to the case, but they're used to inflame the jury against Jesse Duran or in the favor of the plaintiffs in both of those instances. Those are things that 403, substantially more prejudicial than probative, should be used against. It's a very common objection. You're going to have to be able to respond to it. And when you respond to this objection, start by saying, Your Honor, for this testimony to be excluded, the prejudicial effect has to substantially outweigh the probative value. And the probative value of this testimony is blank. That's the scripted response almost that should be coming out of your mouth instinctively whenever you have to respond to a 403 objection. One, you restate the burden that it needs to meet to be kept out, and two, start talking about the probative value it has, ending on, and because it has this probative value, no amount of prejudice could render it inadmissible. Something to those effects. Now I'm going to pull something else up on this screen. This is real life case law here. Don't bother. Like, I'm going to highlight what I'm reading here. I just thought this was really good in explaining 403 in a very legal way, but hopefully one that's understandable. Rule 403 does not provide a shield for defendants who engage in outrageous acts, permitting only the crimes of Kaspar Milquetotes to be described fully to a jury. It does not generally require the government to sanitize its case, to deflate its witnesses' testimony, or to tell its stories in a monotone. So an attorney being passionate or talking about the emotion in a case is not in itself enough to be prejudicial. It does not require plaintiffs to sanitize their case out of fear of emotional prejudice. It's when these specific instances are being described or being likened to the KGB or are being used solely to bring in unwarranted bias that Rule 403 can be used. Use it sparingly, as it says here in this next one. Unless trials are to be conducted on scenarios, on unreal facts tailored and sanitized for the occasion, the application of Rule 403 must be cautious and sparing. The idea here is that real things happen, real things that inflame people's passions, that get people emotional, that get people angry. And if 403 were to be used as some people, especially defense attorneys, would like, then all of those testimonies would have to be sanitized, as the legal community has kind of grasped onto that word. So that's not what 403 is asking us to do. That's not how 403 should be used on your part, because people aren't going to like that. This is like the general prevailing opinion in the legal community about 403. So the application of 403 must be cautious and sparing. There are times it happens more in mock trial than it does in real life, but be cautious in using it, know how to respond to it, and understand how it underlies the rest of the rules. Thanks for watching, and we're going to move on to some character evidence later. Thank you.